Madam Speaker, I rise to speak on Bill C-243, Brian's bill, in honor of the memory of the late Brian Olisic. On June 12, 2012, Brian, along with Michelle Shigelski, Eddie Rehano, and Matthew Schumann, were working as armored guards at the University of Alberta's Hub Mall servicing ATM machines, and they were unfortunately with another co-worker who, in an act of pure evil, opened fire on them, shooting Brian, Michelle, Eddie in the back of the head multiple times, point blank in the back of the head, and as he ran off with $360,000 in cash. Brian, Michelle, and Eddie did not survive. Matthew miraculously did survive, but he has sustained life-altering injuries. His life will never be the same. That triple murderer who attempted to murder a fourth victim, Matthew, was the first murderer to be sentenced under a law passed by the Harper government that simply gave judges the discretion to apply consecutive parole ineligibility periods for multiple murderers, persons convicted of multiple murders, to take into account the life of each victim and to frankly see that the worst of the worst murderers never see the light of day. Alberta Court of Queen's Bench Associate Chief Justice Rook sentenced this triple murderer to 40 years behind bars for taking the lives of three people and attempting to murder a fourth. For Mike and Diane Olisic, Brian's parents, who were constituents of mine when I represented Northwest Edmonton and who I have had the opportunity to get to know over the years, they told me that the only sense of justice, the only sense of comfort that they felt after their son had been brutally murdered was believing that they would never have to sit through a parole hearing in their lifetime to face Brian's murderer. That sense of justice, that sense of comfort, was shattered in May of 2022 when the Supreme Court issued the Bissonnette decision that struck down that very just and that very reasonable law. As a consequence of the Supreme Court's decision, some of Canada's most notorious and worst murderers have seen their sentences significantly slashed. For Mike and Diane, what it meant is that instead of Brian's murderer being eligible for parole in 30 long years as of 2022, he could suddenly be eligible for parole in only 15 years, and today in only 12 years. Mike and Diane came to me as their Member of Parliament and asked what could be done. I said to them that there was a very simple path forward, and that is for the government to invoke the notwithstanding clause to override the Supreme Court's unjust decision. But seeing that the Liberal government was not prepared to invoke the notwithstanding clause, I suggested that at the very least, an amendment be made to the Corrections and Conditional Release Act so that convicted murderers are not able to apply for parole on a frequent basis, year after year, after they have served the mandatory incarceration period of 25 years for first-degree murder and between 10 and 25 years for second-degree murder. Hence, Brian's Law. I championed this in the last Parliament along with Senator Boisvenu, who, like Mike and Diane, knows what it feels like and to live with having a child murdered. And I want to thank Senator Denise Batters and my colleague from Edmonton-Griesbach for bringing forward this bill in this Parliament. And what this bill simply does is provide that someone who is a convicted murderer will have their parole considered, but it will only happen at the time of the automatic review provided for in the Corrections and Conditional Release Act, which occurs approximately every 5 years. Madam Speaker, murder is the most serious offense under the criminal code. It comes with an automatic life sentence, and for good reason. So let's face reality. If someone, for example, is convicted of first-degree murder and they serve the mandatory incarceration period of 25 years, at year 25, their parole will be considered. If at that time the parole board determines that they're not releasable, as is often the case, what are the chances that they are releasable in year 26 or year 27? The chances are next to nil. Yet, as it stands, that murderer would be able to apply year after year after year. How does that make sense? How is that just? How is that fair? How is it just to put the families and friends of murder victims through frequent parole hearings, year after year, re-victimizing them, re-traumatizing them, forcing them to prepare victim impact statements barely after the ink dried from the previous victim impact statement? And to what end? And for what purpose? For a parole application that is almost certainly going to be rejected? Because after all, we're talking about convicted murderers here. We're talking about people who have been given an automatic life sentence. All this bill says is that if you've been convicted of murder, you get a kick at the can every 5 years, as Parliament already determined to be the appropriate time frame for the parole status of a convicted murderer to be reviewed. It's already in the Corrections and Conditional Release Act. So, Madam Speaker, in closing, let me say that this bill strikes the right balance, having regard for the very serious gravity of the offense of murder with the public interest. It takes into account the rights and real vulnerabilities of the family and friends of victims in having to go through frequent parole hearings. It spares the taxpayer of having to foot the bill for frequent, frivolous, and hopeless parole applications. It saves scarce resources at Corrections Canada, and it also respects the rights, the charter rights, as we kept being reminded from the parliamentary secretary and the bloc member, of murderers, because at the end of the day, their parole status, their incarceration status would continue to be reviewed, and it would continue to be reviewed on a fairly frequent basis, roughly every 5 years. Madam Speaker, Brian's bill is straightforward, it's targeted, it's common sense. If this government had any sense of justice and had any regard for the rights of victims, they would vote for it.